My office be granted floor privileges until August 9th, 2024. Krish Kamal, Haley Leipzig, Daniel James, William Duvall, and Chad Schumacher.
Without objection.
Mr. President,
Senator from Kentucky.
if good intentions created good laws, there'd be no need for congressional debate. I have no doubt that the authors of the bill on the floor genuinely want to protect children, but the bill they've written promises to be Pandora's box of unintended consequences. The Kids Online Safety Act, known as KOSA, would impose unprecedented duty of care on internet platforms to mitigate certain harms associated with mental health, such as anxiety, depression, and eating disorders. While proponents of the bill claim that the bill is not designed to regulate content, imposing a duty of care on the internet platforms associated with mental health can only lead to one outcome: the stifling of First Amendment protected speech. Today's children live in a world far different from the one I grew up in, and I'm the first in line to tell kids, go outside, touch grass. With the internet, though, today's children do have some advantages. They have the world at their fingertips. That can often be a good thing, but just about any question can be answered through the internet by finding a scholarly article or a how-to video with a simple search. Doctors and therapists' offices close at night on weekends, but support groups are available 24 hours a day online, 7 days a week, for people who share similar concerns or have heard the same health problems. People can connect, share information, and help each other more easily than ever before. That's the beauty of the technological progress. But the world can also be an ugly place. Like any other tool, the internet can be misused, and parents must be vigilant. Parents must be vigilant in protecting their kids online. It is perhaps understandable that those who sit in this body might seek a government solution to protect children from any harms that may result from spending too much time on the internet. But before we impose a drastic, first-of-its-kind legal duty on online platforms, we should ensure that the positive aspects of the internet are preserved. That means we have to ensure that the First Amendment rights are protected, that these platforms are provided with clear rules so they can comply with the law. Unfortunately, this bill fails to do that in almost every respect. As currently written, this bill is far too vague, and many of its provisions are completely undefined. The bill creates a board empowered to regulate content that might affect mental health. Yet KOSA, the bill, does not explicitly define the term mental health disorder. Instead, it references the 5th edition of the Diagnostic and Statistical Manual of Mental Health, or the most current successor edition. So we're going to regulate items on the internet that might cause anxiety or might affect mental health based on a definition that evolves over time in a book that we're never going to vote on again. It's going to be decided by whoever writes the DSM 6, 7, 8 versions for mental health. But written this way, not only would someone looking at the law not know what the definition is, but even more concerning, this definition could change without any input from Congress. When the diagnostic manual changes, the law will then be changed according to what the new definition of mental health is. The scope of one of the most expansive pieces of federal tech legislation could drastically change overnight. Congress may not even realize it until after it has already happened. The diagnostic manual on mental health changes the definition, the law changes, and Congress had no input on what the definition of mental health is. None of my colleagues would be comfortable with a definition that effectively delegates, or should be comfortable, with a definition that effectively delegates Congress's legislative authority to an unaccountable third party. Second, the bill would impose an unprecedented duty of care on internet platforms to mitigate certain harms. Sounds good. They want to mitigate harms such as anxiety, depression, and eating disorders. But the legislation doesn't define what it considers harmful to minors, and everyone will have a different belief as to what causes harm, much less how online platforms should go about protecting minors from that harm. The sponsors of the bill will tell you it's not a desire to regulate content, but the requirement that platforms mitigate undefined harms to mental health belies the bill's effect to regulate online content. How can you mitigate the effects of things that might cause anxiety because they all involve content? This bill will be setting up a board to regulate the content of the internet. Imposing a duty of care on online platforms to mitigate harms associated with mental health can only lead to one outcome: the stifling of constitutionally protected speech. For example, if online services use endless scrolling to promote Shakespeare's works or algebra problems or the history of the Roman Empire, would any lawmaker consider that to be harmful? I doubt it. And that is because the website design does not do the harm. See, we say we're going to address the design of the website and not the content. The only way they can mitigate the so-called harm is by mitigating the content. It is content, not design, that this bill will regulate. Last year, Harvard Medical School's magazine published a story called Climate Anxiety: The Existential Threat Posed by Climate Change is deeply troubling to many young people. So this bill is going to regulate anxiety. What makes your kid anxious? Well, climate change makes a lot of kids anxious. Are we going to regulate discussion of climate change for minors? This article mentioned that among a cohort of more than 10,000 people between the ages of 16 and 25, 60% of them are described as very worried about the climate, and nearly half said they have anxiety affecting their daily functioning because they're worried about the climate. Are we going to protect them by censoring and removing content about climate change? The world's most famous climate activist, Greta Thunberg, famously suffers from climate anxiety. Should platforms have stopped her from seeing things about the climate warming or cooling or whatever the conjecture is this year? Should they remove that because it makes Greta Thunberg anxious? She's admitted that as a teenager, Greta wouldn't eat. She didn't eat for nearly a year. She lost weight. Some say her growth was stunted. Should we remove climate change discussion from teenagers because it creates anxiety? This bill has the potential to do that. Under this bill, Greta Thunberg would have been considered a minor, and she could have been deprived from engaging online in debates that made her famous, but also made her anxious. Anxiety and eating disorders are two of the undefined harms that this bill expects internet platforms to prevent and mitigate. Are those sites going to allow discussion and debate about the climate? Are they even going to allow the discussion of a person's story about overcoming an eating disorder? That certainly could make people anxious. What if you hear the story of someone with anorexia and it makes you think that you're an anorexic? Instead of getting the moral that it was a bad idea to engage in this sort of psychological problem, it may cause you to be anxious because you now have to address this situation. Could that be regulated? Under this bill, it could. What will happen is fear of liability, fear of lawsuits, fear of what will happen under the penalties of this bill is going to cause people to censor themselves. Online platforms will be forced or feel themselves forced or coerced to censor themselves. There is a question: will pictures of thin models be tolerated, lest it result in eating disorder? Or for the people who see them. There's a discussion of this all over. There are now, everybody sees the obese models that are now hired for Sports Illustrated in order to not cause anxiety. Well, if that's done voluntarily by a magazine, by all means. But if we're going to coerce these online platforms and say, you can't show people that are too thin, what's too thin? That's what this bill one of the results that could happen from this bill. What about images, violent images of war? I think even adults are made anxious by that, but what of kids? Should we restrict images of war? There's a war going on in Gaza, and there's a lot of young people with opinions on that. Should we say, well, young people shouldn't be allowed to see images from Gaza because it might make them anxious? Should we silence discussions about gun rights from either side, from the right or the left, because it might cause people anxiety? I would think that if you've been in a school where there was a school shooting, every time you read about it, it probably causes you anxiety. Should this be something that parents should try to address, psychologists, psychiatrists? By all means, parents should be involved in what their kids do online. But once the government sets it up, it depends on who's on the board. So if the Democrats are in power and they aren't real fond of the Second Amendment, if they're in power, my guess is the people they appoint to the board will believe that gun ownership or gun use is wrong and causes anxiety and shouldn't be on children's sight. Conversely, when the Republicans are in charge and we're more for allowing the Constitution to be applied through the Second Amendment to gun ownership, we probably would want to police people telling kids they're not allowed to, or that the Constitution. It works both ways. There's enough to hate this bill from the right and the left because the government shouldn't be making these blanket decisions. What of online discussions of sexuality? Would pro-gay or anti-gay discussion cause anxiety in teenagers? I would think it might. This bill would allow the children's online safety to regulate things that cause anxiety. If discussion of sexuality causes anxiety, it would be eligible under this bill for mitigation. They didn't want to use the word censorship because it sounds bad, but that's what they want to do. They're appointing a committee called the Children's Online Safety Council, which will be able to censor things that cause anxiety: climate change, sexuality. What about pro-life messaging? Should pro-life discussions cause anxiety in teenage mothers considering abortion? Well, I'm guessing that whole scenario from either the pro-life or the pro-abortion perspective is full of anxiety. But are we going to protect the teenage mom who might be offended that a pregnancy center is offering her a way out or offering her a lifeline to have her child? Because maybe somebody else thinks that she should have an abortion. Maybe she decides one way or another. But it's anxiety. It's probably full of more anxiety than most of us can imagine. But are we going to ban teenagers from seeing that? This is insane. This bill is not well thought out. This bill is Pandora's box for censorship. In truth, this bill opens the door to nearly limitless content regulation, as people can and will argue that most any piece of content could contribute to some form of mental health disorder. In addition, financial concerns may cause online forums to eliminate all anxiety-inducing content for all users, regardless of age, if the expense for policing teenagers is prohibitive. So think about it. If we make this onerous process that adds a great deal of cost to the people developing the websites, and they have to be liable and the state attorney generals can sue them, which this bill allows, maybe they say, gosh, is it worth my while having any discussion of anxiety-producing content, which basically means things that are controversial. Maybe we should stay away from that. Maybe there will be a self-policing effect to this bill that people say, I'm not even going to do it for my adult users because I don't want to be sued. The bill gives the unlimited right and cause of action for every state attorney general. Some of them are on the far left, some of them are on the far right, and you can imagine each of them have their own pet causes to want to sue to say, you should take this content down. This bill does not merely regulate the internet, it threatens to stifle important and diverse discussions that are essential to a free society. And who is empowered to help make these decisions? The task is entrusted to a newly established speech police. This bill would create a Kids Online Safety Council, aka Speech Police, to decide what constitutes harm to minors and what platforms would have to do to address the harm. So the harms are broadly defined: mental health, anxiety, gambling, alcohol. But then the specifics of how it's going to be regulated are left to this new regulatory body. This is what many on the right have referred to as giving the power to bureaucrats. There was a famous case called the Chevron case where they said the government should give deference to anything created by government. Now, that's under review now, but this is the same problem. You're giving power to this new group that can censor that is virtually unlimited and ill-defined. These are the types of decisions that should be made by parents and families, not unelected bureaucrats serving as a censorship committee. Those are not the only deficiencies of this bill. The bill seeks to protect minors from beer and gambling ads on certain online platforms. Not everywhere, just some places. So we're going to put this duty on some platforms that your kid can't watch gambling ads and can't watch beer ads, but on other platforms we won't. So there will be a differential to financial cost. Some places won't have to pay anything, and other places will have to pay an amount to figure out how to set up a website that doesn't let kids watch golf with gambling commercials. The bill seeks to protect kids from beer and gambling ads on certain online platforms, such as Facebook or Hulu, but if those same minors turn their phone off and turn their TV on, they can jolly well watch as much PGA with the announcer saying, FanDuel says gamble on, Bryson DeChambeau this week, or Rory McIlroy. This is a bizarre bill. We're going to make it illegal to talk about certain things online or to advertise online for gambling or beer that your kid can simply turn the TV on and watch PGA, which is full of ads. And you can have a variety of opinions on whether we should have gambling ads on TV, but they're perfectly legal. So we're going to punish certain groups on the internet and still say your kid can just turn the TV on. That's bizarre. It's just completely meaningless and bizarre. Your kid can watch the Super Bowl with about 1,000 beer commercials on it. And I really, I haven't really heard of a lot of people jumping up and down and saying we should ban the Super Bowl, or we should say the Super Bowl can't have beer ads, but that's what this says. So all the stuff your kid can watch on TV, he's now going to be limited, not on the whole internet, because you can go to PGA.com and it's got an exemption because it's primarily news or sports. So they carved out all these exemptions, and then there's going to be certain areas you can't go to on the internet. So this is a punishment bill for certain aspects of the internet, not all of the internet, because there's a lot of exceptions, and not for TV. This is a crazy notion, and you're going to see it pass overwhelmingly today. Because of the title, Kids Online Safety Act, who could oppose that? And there are some tragic stories of people who have committed suicide or died because of things that happen on the internet. No one is here to discount that. But it has to be thoughtful how we fix it. Is removing all discussion of climate change, abortion, gambling ads, and beer ads going to do anything that would have addressed the life of any of the children who tragically have lost their lives? I think not. This is a ham-fisted bill that will not fix the problem, but will be the first big bill to regulate speech online. Doesn't make any sense. Should we prevent online platforms from showing kids the same content they can and do see on TV? Should sports viewership be effectively relegated to the pre-internet age? You can watch golf on TV, you can't watch golf on a streaming service. And even if it were possible to shield minors from every piece of content that might cause anxiety, depression, or eating disorders, it's still not enough to comply with KOSA. KOSA, the bill, because KOSA requires websites to treat differently individuals that the platform knows or should have known are minors. As you can realize, it's not easy to tell what someone's age is online. The standard had been, if there were rules for minors, you had to know they were a minor and you had to know you were broadcasting adult content to a minor. But it's kind of hard to enforce. So they're going to change the standard from you knew it was a minor to you should have known it was a minor. This means that the media platforms who earnestly try to comply with the law could be punished because the government thinks it should have known a user was a minor. This dumbing down of the standard will broaden the fear of this bill, broaden the impact of this bill, and lead to countless lawsuits. This bill then does not just apply to minors. A should have known standard means that this bill is an internet-wide regulation. Every website will have to figure out who and how old they are so they don't get in the way of the speech police, or they don't get in the way of being sued by the Attorney General from that state. This is opening Pandora's box. It's not going to be just sites that might have kids. It's every website, every streaming service is now going to have to police themselves, add cost, and live in fear of these people coming after them. Adults and minors alike better get comfortable with providing a form of ID every time they wish to visit a website. This knowledge standard destroys the notion of internet privacy and interactivity. I've raised several questions about this bill today, but no one, not even the sponsors of this bill, can answer these questions honestly because they don't know the answers. They're creating something that's going to create the regulation of the internet. This is a problem of most legislation in Washington. They're not creating the censorship standards. They're creating an autonomous body that will regulate things that cause anxiety. They haven't told us what causes anxiety. So I've given you examples. They're not in the bill because the bill doesn't tell what this new body is going to regulate. It says things that cause anxiety, things that might involve gambling or beer or eating disorders. It could be any of those things, but they're just going to tell you that we're going to let this body decide. So the Senate's not going to decide what they're going to censor today. They're going to create a committee today that then will be the censorship committee, and at a later date will decide what they want to censor. This is an insane encroachment on the First Amendment. The inability to answer these questions is a result of several vague provisions in this bill. And once enacted into law, these questions will not be answered by elected representatives. They will be answered by unelected bureaucrats who are on this council who will make the decision as to what will be censored. There are good reasons to think that the courts will strike this bill down. They would have a host of reasons to do so. Vagueness pervades the bill. The most meaningful terms are undefined, making compliance with the bill nearly impossible. Even if we discount the many and obvious First Amendment violations inherent in this bill, the courts will likely find this bill void for vagueness. We can only hope so. But we should not rely on the courts to save America from this poorly drafted bill. The Senate can reject this bill today and force the sponsors to at least provide greater clarity of the bill. This bill, KOSA, is a Trojan horse. It purports to protect our children by claiming limitless ability to regulate speech and depriving them of the benefits of the internet, which include engaging with like-minded individuals, expressing themselves freely, as well as participating in debates, among others, with different opinions. Government mandates and censorship will not protect children online. The internet may pose new problems, but there is an age-old solution to this issue. Free minds and parental guidance are the best means to protect our children online. Opposition to this bill is bipartisan, from advocates on the right to the left. A pro-life organization, Students for Life Action, commented on this bill stating that once again, a piece of federal legislation with broad powers, vague definitions, threatens pro-life speech. Those targeted by a weaponized federal government will always include pro-life Americans, defending mothers and their children, born and unborn. Students for Life Action concludes their statement by saying, already the pro-life generation faces discrimination, deplatforming, and short and long-term bans on social media on the whims of others. Students for Life calls for a no vote on this bill to prevent viewpoint discrimination from becoming federal policy at the FTC. So you could say, I don't really care. I'm on the other side of that issue. I'm a liberal, and I'm pro-abortion. I don't care what pro-life students say. Well, maybe you should care what the ACLU has to say about this. The ACLU brought more than 300 high school students to Capitol Hill to urge Congress to vote no on this bill because, to quote the ACLU, it would give the government the power to decide what content is dangerous to young people, enabling censorship and endangering access to important resources like gender identity support, mental health materials, and reproductive health care. So here you have it. You have people on one side who are pro-life, like myself, who are worried that pro-life language will be stifled because it might cause anxiety in teenagers. But you have people on the other side, such as the ACLU, who would have, I believe when they refer to reproductive health care talking about abortion, are worried that people in favor of abortion would be stifled as well. This bill is opposed from the right and the left by anybody who is thoughtful about freedom of speech, about freedom of association, about freedom of discussion of ideas online. In the next few minutes, I will ask unanimous consent to have an amendment to this bill. And what you'll notice is, while the supporters of this bill will come forward and say, doesn't do that, it doesn't do that, the one thing's for certain is they won't allow amendments to this. So there will be no amendments to this bill. The reason I'm asking for an amendment from the floor is because they've already said privately they will not allow amendments. The one reason they won't allow amendments is when I read the content of my amendment, people would be aghast that anybody could vote against it. And a vote against it would be deeply damaging to people running from office for Republican or Democrat. The bill contains too many flaws as is. Even my one amendment wouldn't fix this bill, but at least put people on the record who don't believe that there should be restrictions from limiting religious or social speech. The Senate should tackle the most glaring problem with this bill, that it will silence political, social, and religious speech. My amendment seeks to address this concern, shared by many in the pro-life movement, as well as anyone who values the principles of free speech. My amendment merely states that no regulations that will be put forward by this magical and mysterious new censorship police that will be in the future, who we don't know who they were, and we don't know what they'll be regulating, but they will not be, if my amendment were to pass, they will not be allowed to regulate, and it will not apply to political, social, and religious speech. Another name for that would be constitutionally protected speech. My amendment is intended to address the legitimate concern that the bill threatens free speech online. If the supporters of this legislation really want to leave content alone, they'd allow the amendment. So the fact that they will deny me this amendment effectively tells Americans they don't want any dissent, and they acknowledge that this is a bill of censorship. They don't want anything to mitigate or lessen the ability for the committee to censor you, and so they will not allow this amendment. They won't even allow a vote on it because they're afraid to be on record. And really, the sponsors of the bill are here today, and they will rebut my words. I would like them to state publicly for all of us how they would vote on the amendment and why they're blocking the amendment. If the supporters of this legislation really do want to leave content alone, they will welcome and vote for my amendment to protect political, social, and religious speech. I ask unanimous consent that if cloture is invoked on the motion to concur with further amendments in House Amendment to S2073, Amendment number 3022 be set aside and be in order for me to call up my amendment 3085. I further ask that a time to be determined by the majority leader in consultation with the Republican leader, that there be 30 minutes of debate equally divided between the proponents and opponents of my amendment. Finally, following the use of yielding back of that time, the Senate vote on my amendment 3085 with no intervening action or debate.
Is there objection?
Mr. President,
Senator from Connecticut.
reserving the right to object. I've listened to my colleague from Kentucky, and in the interest of time, I think the very simple answer and the reason for my objection is read the bill. Read the bill. If you read the bill, you will see, for example, there is no empowering of attorneys general to enforce this measure. There is no vagueness in these provisions. They were crafted narrowly to target specific evils, real evils, that destroy lives. And if he thinks that this bill, as he has termed it, is crazy and bizarre, he should tell the parents and the young people who have come to us over these past years, to Senator Blackburn and myself, with harrowing stories of the destructive harm to their children's lives, and young people telling us about those harms to their own lives. The principle of this bill is very simple. It does not empower those unelected bureaucrats, which again, unfortunately, our colleague from Kentucky has misread. It empowers young people and parents. It gives them choices. It enables them to take back control over their own lives. It enables the strongest settings of safety by default. It requires companies to disable product features that are destructive. It gives young people and parents tools to opt out, to choose not to be a part of algorithm recommendations that fuel destructive mental health harms. It gives them safeguards to shield themselves against online predators and options to protect their own information. Young people and parents deserve these kinds of choices to make on their own. That is the principle of the bill. And so this mischaracterization is regrettable, but I know that my colleagues are going to see through it. They're going to see that this bill is very specific, not vague, narrowly targeted, not broad, to protect children and give parents and kids choices that enable them to take back control over their own lives. And let me just say, there's no censorship in this bill. None. Zero. It is about product design, much as it would be about a car that is unsafe and is required to have seat belts and airbags. We wouldn't credit an argument by a car manufacturer that somehow it's a First Amendment right of expression to eliminate those car seats and airbags that protect lives. It would be ludicrous. It would be laughable. And so are these objections that have been made by my colleague from Kentucky. I am proud of the work that we have done on a bipartisan basis over these years. This bill is the result of a bipartisan, careful, methodical, time-consuming work by Senator Blackburn and myself, listening to those parents and young people, but also, and let me be very blunt here, listening to the big tech companies. They've come to us and they've said, in effect, trust us. Trust us. We'll take care of it. We've seen this movie before. We know how it ends. No action. Trust us is no longer tolerable. And one reason it's no longer tolerable is we've looked under the hood. We've seen how the car works. We've seen it from their own documents, their own files, their own written product designs. And we've seen their business model, which is repetitive, toxic stuff driven at kids, and more eyeballs, meaning more advertisers, meaning more dollars if those kids are online for longer periods of time without the choices that we are giving them to disconnect. We are no longer going to trust big tech to do the job. We are determined that we will make this product safer by empowering young people and their parents and create a duty of care. Not vague, not overbroad, but carefully crafted to make sure that these companies have to prevent the kind of harms that they know are happening. We know they're happening because the documents show it, and their own evidence, in effect, proves it. And we're not going to trust them anymore to comply with the law. We're going to require audits and transparency, access to the black box algorithms, so that they are held accountable. This bill is a major step toward online safety for children. And I am hopeful that my colleagues will, in fact, see through the inaccuracies in the arguments that have just been made here, and that they will join Senator Blackburn and me, as 70 have done in co-sponsoring this measure, to say it's time for online safety. I yield to my colleague from Tennessee, Senator Blackburn, who has been a steadfast and invaluable partner in this effort.
Thank you. Thank you, Mr. President.
Senator from Tennessee.
Thank you, Mr. President. And I thank my colleague who has worked so diligently on this. This legislation has been years in the making, as he has said. Basically, the amending process has gone on for 3 years. And as he mentioned, 70 members of this body have joined to sponsor this legislation. To the concerns that my colleague expressed, I want him to know this is not a speech bill. This is not a content bill. No agency can make rules on speech. Nonprofits are not covered in this bill. There's no rulemaking. News outlets are not covered in this. The government is given no new authority. And when he mentioned websites and blogs, the Kids Online Safety Act only covers social media, social networks, multiplayer online video games, social messaging apps, video streaming services. It does not include blogs and personal websites. Now, the question, he was saying that Kids Online Safety Act covers platforms that are run by nonprofits. No websites run by nonprofit organizations, which often host important and valuable education and support services, are not covered in the scope of this legislation. And these are important points to make. And as Senator Blumenthal said, reading the bill, you see this is a product design. The duty of care that is there, it requires social media companies to prevent and mitigate certain harms that they know their platforms and products are causing to young users as a result of their design choices, such as their recommendation algorithms, their addictive product features. The specific covered harms include suicide, eating disorders, substance use disorders, and sexual exploitation. And these are the reasons for having this duty of care and having this included in the Kids Online Safety Act. But no, it is not a speech bill. It is not a content bill. It does not include rule-making authority. It has no rule-making authority in the legislation, and it does not give authority, additional authority to the government, and it does not give more authority to state attorneys general or to the FTC. So I think the fears are unfounded. This is a good product, good legislation. We have worked with our colleagues. We have heard from thousands of kids and parents, pediatricians, teachers, principals, mental health professionals, and everyone has come to the table to say it is time to hold big tech accountable for what is happening to our kids. And I yield back to my colleague from Connecticut.
Is there objection?
Mr. President, I just want to add, and I thank Senator Blackburn for her excellent summary and argument, this reference to social speech. We're dealing here with social media companies. This proposed rule of construction, in effect, would destroy the bill. That's the intent here, and we're not going to let it happen. I object.
The objection is heard.
President,
Senator from Kentucky.
a few comments on the support the authors of the bill have come forward with. The discussion is that state attorneys are not empowered, when in actuality, if you read the bill, the state attorneys are empowered. They're specifically referred to in the bill, and they are specifically empowered to sue if and when the Child Online Safety Committee promulgates rules through the FTC. This is specifically given to not only state attorneys, but also the rulemaking authority is given in the bill. State attorney generals will also be allowed to sue even if no rule is made. This does empower state attorney generals across the nation to sue over whether or not people are adequately suppressing or censoring speech based on anxiety. So that is a factual dispute we have with the authors. One of the authors says, we can't trust the online people. We can't trust the people hosting these platforms. Well, of course you can't. That's why you're supposed to be parents. That's why you're supposed to be involved with your church and community, and you're supposed to try to police. Everything's imperfect, but you're supposed to try. It isn't the government. So he says, we can't trust them. But you know what? I've also heard another comment. Trust us, we're from the government. Trust us, we're going to give this Child Online Safety Committee unlimited, unchecked power to regulate anything that causes your teenager to be anxiety, from climate change to sexuality to who knows what, to eating disorders, to thin models, to gambling on the PGA or any website or beer commercials. This is Pandora's box, and we need to be aware of what it actually does allow to occur. The rule of construction, the amendment that is being blocked, is typical. This is a bill to block free speech. So in order to pass a bill to block free speech, you block the free speech on the floor of the Senate and disallow amendments. Who in America would think it would be wrong to limit this bill and to protect political, social, and religious speech? That's what they're actually saying. They won't allow amendment on it, but they are not for exempting political, social, or religious speech. What does that mean? It means they conclude that the bill will allow regulation of political, social, and religious speech. Mark my words, we will revisit this issue. The court's either going to strike this thing down, or we're going to come back here in a year or two and people are going to go, oh my God, did anybody read the bill before they passed it? They have 70 co-sponsors because nobody reads the bills. Nobody thinks of the implications of the bill. The bill gives virtually unlimited purview to the Children's Online Safety Council to determine what causes anxiety. Everything causes anxiety in teenagers. Every controversial subject could potentially cause anxiety. This is a huge mistake to give this authority to unelected bureaucrats who we don't know who they are yet or who will appoint them, who will make the decisions over what causes anxiety. So while these people, I grant them good motives, I grant them wanting to do the best for people, I grant that there are terrible and tragic cases where children have committed suicide or otherwise, but this isn't the answer. The answer isn't to abbreviate or take away the precious rights guaranteed under the First Amendment.